FS Cairo, Nile Plaza, LLC, Appellant, against Lady Brownlie, Respondent.
Lord Lloyd-Jones will explain the judgment of the court.
This case concerns a challenge to the jurisdiction of the English courts to hear certain claims arising from a road traffic accident which occurred in Egypt. In January 2010, Lady Brownlie and her husband, Sir Ian Brownlie, were holidaying with several family members in Egypt. They stayed at the Four Seasons Hotel Cairo at Nile Plaza. On the 3rd of January 2010, Sir Ian and Lady Brownlie went on a driving tour, which Lady Brownlie had booked through their hotel. While they were on the tour, their car crashed, killing Sir Ian and seriously injuring Lady Brownlie. On the 19th of December 2012, Lady Brownlie issued a claim in England, seeking damages in both contract and tort. The case ultimately reached the Supreme Court. It emerged during the proceedings before this court that Lady Brownlie had named the wrong defendant in her claim. The Supreme Court therefore found that Lady Brownlie's claims could not proceed, although she was granted permission to apply to change the name of the defendant. On the 1st of October 2019, Lady Brownlie received permission from the High Court to serve her claim out of the jurisdiction on the current defendant. The defendant appealed to the Court of Appeal, which dismissed its appeal. The defendant now appeals to the Supreme Court. The court may grant permission to a claimant to serve a claim out of the jurisdiction if three conditions are met. First, the claim must fall within one of the jurisdictional gateways which are set out in the civil procedure rules. Secondly, the claim must have a reasonable prospect of success. Thirdly, England and Wales must be the appropriate forum in which to bring the claim. Those conditions may be described as the domestic rules regarding jurisdiction. There are also EU rules regarding jurisdiction which have operated in parallel to the domestic system, but which do not apply in this case. This appeal raises two issues. The first is the tort gateway issue. It concerns whether Lady Brownlie's claims in tort pass through the jurisdictional gateway on which she relies. The second issue is whether Lady Brownlie has established that her claims in both contract and tort have a reasonable prospect of success. On the foreign law issue, the Supreme Court is unanimous in dismissing the appeal. Lord Leggatt delivers a judgment with which the other members of the court agree. On the tort gateway issue, Lord Lloyd-Jones delivers a judgment with which Lord Reid, Lord Briggs and Lord Burrows agree, holding that the appeal should be dismissed. Lord Leggatt would have allowed the appeal on that issue only, and he delivers a dissenting judgment. As to the tort gateway issue, the appellant submits that Lady Brownlie's claims do not meet the criteria for the gateway which applies to claims where damage was sustained within the jurisdiction. The appellant argues that the initial or direct damage must be sustained within England and Wales for the gateway to apply. Lady Brownlie instead maintains that if significant damage is sustained in the jurisdiction, then the requirements of the gateway are met. The court considers that damage refers to any actionable harm, direct or indirect, which is caused by the wrongful act alleged. Damage should not be limited to the damage which is necessary to complete a cause of action in tort. That approach would be unduly restrictive. The notion that this gateway should be interpreted in light of the distinction between direct and indirect damage, which has developed in the EU system regarding jurisdiction, is also misplaced. In the court's view, it is an overgeneralization to state that the gateway was intended to assimilate the domestic rules within the EU system. Indeed, there are fundamental differences between the EU rules and the domestic system. Because Lady Brownlie's claims in tort relate to actionable harm, which was sustained in England, they pass through the tort gateway. For these reasons, the appellant's appeal on the tort gateway issue is dismissed. Turning to the foreign law issue, the parties now agree that Lady Brownlie's claims are governed by Egyptian law. One of the requirements for obtaining permission for service out of the jurisdiction is that the claim, as it has been pleaded, has a reasonable prospect of success. The appellant argues that certain of Lady Brownlie's claims do not have a reasonable prospect of success because she has not provided sufficient evidence of Egyptian law. Lady Brownlie instead submits that she may rely on the rule that in the absence of satisfactory evidence of foreign law, the court will apply English law. The court distinguishes between two conceptually distinct rules of law, the default rule on the one hand and the presumption of similarity on the other. The default rule is not concerned with establishing the content of foreign law. It instead treats English law as applicable in its own right when foreign law has not been pleaded by the parties. The justification for the default rule is that if a party decides not to rely on a particular rule of law, then the court should not apply it of its own motion. However, if a party does plead that foreign law is applicable, they must then show that they have a good claim or defense under that law. In contrast, the presumption of similarity is a rule of evidence which is concerned with what the content of foreign law should be taken to be. This presumption applies only where it is reasonable to expect that the applicable foreign law is likely to be materially similar to English law. Lady Brownlie's claims are pleaded under Egyptian law. The default rule cannot therefore apply because Lady Brownlie has decided to rely on Egyptian law. However, in this case, the judge was entitled to rely on the presumption that Egyptian law is materially similar to English law in concluding that Lady Brownlie's claims are reasonably arguable for the purposes of establishing jurisdiction. Accordingly, the appellant's appeal on the foreign law issue is also dismissed.